Uganda, the Spy Television, Andrew Iriumbale, I'm in Fort Poto, I'm in Ngamije Advocates.
Yes, law consultants and advocates.
Yes, comrade Soko Yanzura Manyago.
My name is Murungi Godfrey, Mpaka Atenyi, and I'm an advocate based in Fort Poto City. I'm an enrolled advocate, so I'm licensed to practice before all the courts of judicature.
Okay, now my question is one. Last night, the judge Musa Sekaana sentenced your president to 2 years imprisonment for contempt of court.
Yes.
I wanted your opinion on this.
My opinion is it's an unfortunate incident because contempt is one now of the avenues some of our judges are now using in courts to harass their enemies. We as advocates, we understand that contempt of court must only be or is only committed in the courtroom or in the vicinity of court or in your pleadings. And it is the only offense that which is not written under the law, and even the sentence is not prescribed. And the purpose of contempt proceedings is to instill discipline, to make sure that the courts are respected and the judges are respected. But somebody cannot commit contempt when he's not in court or he has not drafted pleadings that, in the opinion of court, disrespect the court. Court can only be disrespected by somebody who is within the vicinity or in the pleadings drafted by.
You must be in Musa Sekaana's court for you to commit a crime called contempt of court. Or you must have written to him.
In your pleadings.
In your pleadings.
Either in your submissions or in your documents.
You write to him.
You can write.
And in your writings, you commit an offense.
You make
contempt of court.
Yes,
maybe by abusing him in writing.
Yes.
Or by physically abusing him in court.
Yes.
In his court.
Yes. Or disrupting the business of court.
That means you must be present in his court.
But anything outside the vicinity of court or anything that is not in the court pleadings, that one cannot amount to contempt.
So now, Sekaana has quoted in his ruling some of the alleged crimes that President Isaac Samakad committed. He committed them via X platform, social media. Those are the things he has quoted. Can that amount to contempt?
In my well-thought opinion, no. Because if I go and write or I say anything outside court that you feel is defamatory, it is not true. The only remedy you have is to file a defamation case against me.
Not contempt.
Not contempt.
But defamation.
Defamation. And which you cannot determine as the judge. You are a complainant, you are a plaintiff in that case, so you cannot determine that case. But with the contempt of court, you have the discretion to determine whether someone's conduct is contemptuous or not. So in my opinion, it is wrong for judges and the judicial officers to use this provision of the law to instill discipline. There is a disciplinary committee of the law council. Even the court itself can discipline an advocate because we are officers of court, but it should not go to extremes. Because sentencing a president of the Uganda Law Society, he's the head of the bar now. He's the president of the bar association.
They're trying to cripple your association.
So
the leadership.
That is our voice.
So by doing so, they're trying to cripple.
They are trying to cripple how our work should be done, and we cannot access our court users as litigants are going to lose confidence in the judiciary because of how it is apparently treating lawyers, how it's seen. These are people who are not supposed to be emotional. So most of their rulings are sentimental.
Nowadays.
Yes. So what we need are reforms. maybe it is high time that we curtailed powers, discretionary powers of judicial officers to how they determine or how they arrive at such sentences, because those are extremely harsh sentences. 2 years is extremely harsh. There is even an option of a fine. But contempt of court is only committed in a court or through the pleadings. But if you go on a radio station and they say something and you feel it is not true, you go and prefer defamatory charges against me. That is it, sir.
Yeah. So now, there's something you said, that of all the things that the Constitution has catered for, they have not catered for what you called
what the Constitution says
the contempt of court.
Yes.
There is no.
It is the only offense.
Yes.
Whose ingredients and punishment is not prescribed under the law. So that one is left to the discretion of the judicial officer.
So judicial officer can even sentence you to 10 years.
Absolutely.
So what is the problem? Why don't you also prescribe it that the maximum sentence for this shall be this? What is the problem?
Now,
why are you leaving it to sentimental judges?
Now the challenge is that some judicial officers are very conservative. Others are liberal. What may constitute contempt to a liberal judge may not constitute contempt to a conservative judge. So that is why they should be stripped of that power. It is high time that the Constitution is amended and the offense of contempt included in our penal laws.
So that is clear what amounts to contempt.
What amounts to contempt
of court.
Because now it is very broad, but the biggest problem is not even the offense itself. It is the punishment. The punishment should be prescribed. Yes.
Kale, thank you so much, comrade. Andrew Irumba Live, the Spy Uganda, the Spy Television in Fort Portal Town. Kale.